Okay, thanks everyone for joining our webinar on the new overtime rules. Welcome. Looks like we have a lot of interest in the subject. We have quite a few attendees. My name is Sunil Rajaraman. I am the head of marketing at Replicon, and I'm joined here today by Andrew Anderson from Trunk Club and Brian Dixon from Littler Mendelson, two great guests to talk about how to navigate the new overtime rules. Andrew joins us from the company side and has to deal with implementing the new overtime rules. And Brian is a very prominent wage and hour attorney and is an expert on the new overtime rules. Andrew, perhaps you could tell us a little bit more about what your specific role is at Trunk Club and do a brief intro.
Sure, I'm Andrew Anderson. I am the HRIS and payroll manager here for the firm. And Trunk Club is a subsidiary of Nordstrom with about 1,300 employees at the moment.
Brian?
Thank you, Sunil. My name is Brian Dixon. I'm co-chair of the Wage and Hour Practice Group at Littler Mendelson. The practice group includes about 400 attorneys across the United States. I have enjoyed practicing wage and hour law since long before it was fashionable. I've written several books on the subjects, regularly lecture on the subjects, and enjoy the opportunity through Replicon to do webinars on the subject.
Brian and I are old veterans at this. We've done a few webinars, so look forward to hearing both Andrew and Brian's perspective. Next slide, please. Okay, we always start off with a comic. It's become tradition on these overtime webinars. As I mentioned, we've done a few of these before, so we'll let you digest this and get you in the mood for discussing overtime. Okay, so our agenda for today. We will obviously be discussing what the new overtime rule is and go over some frequently asked questions. In the past, we've done a pretty extensive presentation portion, but today we're going to be addressing a lot of your questions directly and focusing more on the Q&A that we've learned over the past several webinars and ask Andrew some questions directly about what he's dealing with operationally. So a bit of basic housekeeping. Everybody's on mute at the moment, and Q&A will take place at the end of the webinar. For any attendees who want to submit questions, please do so now. It looks like we have hundreds of attendees on this webinar, so a lot of interest in the subject. You can submit via GoToWebinar, and we will look at everybody's questions. We may not get to all of them, but we will definitely do our best. We prioritized some of the questions that came in advance of the webinar, but please submit your questions and we will get to them, if not on the webinar, immediately after. And then we will be going through a brief presentation portion plus brief Q&A for 20 to 30 minutes, and then we'll turn it over to audience Q&A immediately after. Look forward to seeing your questions, and let's get started. Brian, over to you.
Thank you very much. We have the interesting challenge of a substantial increase in the wage rate that has to occur on December 1st. We want to remember that the salary pay requirement is a weekly requirement. One of the interesting things about the effective date of the change is that it occurs on a Thursday. Carefully plotted to be the Thursday after Thanksgiving. Many people will give thanks for the salary increase. There's not a lot of clarity, or because it's a weekly pay requirement, there's not a horrible amount of clarity right now about whether you have to pay the salary for the entire week, which would actually make the for somebody who has a Sunday work week, would require you to make the pay rate change effective the Sunday before, say if you're using the calendar week, which would be late November. And that's certainly the prudent thing to do in the absence of further guidance. I want to emphasize that what we're looking at is a change in the minimum salary in order to be a white-collar, overtime exempt employee. This is not a minimum wage increase. People who are paid overtime can be paid anything down to the federal minimum wage, which is now, generally speaking, $7.25 an hour for non-government contractors. The other distinctive increase about the raise that will occur for exempt employees, so to speak, is that it will automatically index and change every January 1st of every third year. So our first change will occur in 2020. The duties test for the exemptions was not changed. That was a very interesting development. There had been some suggestion in earlier disclosures from the Department of Labor that they would be looking at the duties test, particularly at the executive exemption and whether an exempt employee could contemporaneously do both exempt and non-exempt work, but that remains unchanged. Good news, minimizing impact. The definition of a highly, or at least the salary for a highly compensated employee, will increase from $100,000 annually to $134,000 annually. Distinctively new and cushioning the impact of this change for a variety of employers is the fact that you can now credit against the lower of the two salary rates, I'll call it the base salary, of $47,476 a year or $913 a week, is that you can take a credit for non-discretionary incentive compensation, which is paid quarterly, of 10% of the salary. In other words, you could pay a base salary of $821.70 dollars per week, as long as at least quarterly, if not more frequently, the employee receives non-discretionary incentive compensation in an amount that would make up the difference between the $821.70 and the generally applicable $913 a week. Take a look at the next slide. Where are we going historically? What's going to happen to us in 2020? In 2020, we're probably going to see, given current projections of the change in the cost of living, an increase of the base salary from $47,476 to $51,000, and a commensurate increase in the exemption for highly compensated employees. One further note about highly compensated employees is that you cannot use the 10% credit of non-discretionary incentive compensation to make that up. You have to pay that salary on a weekly basis every week of the year in order to take advantage of that reduced, the somewhat narrower duties test for highly compensated employees. Let's go on and take a look at the next slide and the options that an employer has when it comes down to complying with the new rule. Well, for those people who are in the wage band between $455 a week and the new $913 per week, you've got decisions to make. Easiest decision, of course, would be to just start paying overtime. Very convenient if an employee doesn't work much overtime, but if an employee works a lot of overtime, we have to do a little more math, and we'll come back to that in a moment. You can also raise salaries in order to keep an employee overtime exempt. The Department of Labor, I think, was thinking there would be more salary movement, and more in the way of wages paid, but the trend in employers seems to be a little bit in the other direction. That is, control costs, limit overtime, limit salary increases. And of course, you can choose, you can limit hours of work, but one of the important things I think that's to bear in mind is that the group of employees who are paid a salary between $455 a week and $913 a week are people with more responsibility, more diverse and diffuse responsibilities. Defining hours work for them may be a little more difficult. Trying to shoehorn them into don't ever work more than 40 hours in a week could be a bit of a challenge, I think, in real terms. So we have to be always realistic when we talk about limiting hours of work. Let's take a look at the next slide. So we think about salary increases in order to maintain an exempt employee. That, again, is someone who's earning between $455 a week and $913 a week. And we could think of a salary increase as one way to to continue to treat that employee as an exempt employee. I do have to say, you never want to lose track of the duties tests for exempt status. If you're a salaried exempt executive, administrative, or professional employee, the duties tests do have to be met. For a lot of employers, in many regards, the salary increase is a way of addressing some employees who, that HR might have had some, or payroll had some reservations as to whether they're truly exempt. The salary goes up. We have a good reason to go to the employee and say, we're going to start paying you overtime, and we don't have to do, an audit to ensure that the employee is in fact meeting the duties requirements. We are thinking about an increase in salary. We do want to do the math. If someone's paid a little bit below the new salary rate and doesn't work much overtime, we can be a little bit indifferent. We might raise the salary and we wouldn't incur much in the way of additional cost. If somebody is, substantially below the new salary threshold and doesn't work much overtime, perhaps best just to make that employee non-exempt. If you're moderately below the new salary threshold and you work a lot of overtime, then an employer has to think harder about, well, maybe a salary increase would be the ultimate cost savings here. And we want to think of some of the collaterals if we continue to treat the employee as exempt. Exempt employees are a little more task-oriented rather than time-oriented, and there's an advantage for an employer in maintaining that exempt status and that focus. We need to anticipate a few things here. If we give everyone a pay raise just to be over the new salary threshold, what happens to the employees who are now perhaps their superiors who are just over the salary threshold? We wind up with what we call compression. And you can always solve compression by moving everyone up a little bit, to make sure that the differential is maintained. But for a lot of employers, that is another reason to think perhaps going to non-exempt status is better. And we also want to remember that we're going to have an automatic adjustment in the threshold at which employees can qualify as exempt employees in 2020. And we could have, if we're squeezing a lot now, we've got a lot of compression, we're going to have even more in 2020. So something to bear in mind.
Hey, Brian, at this point, I'm gonna interject a little bit and get Andrew to talk a little bit about the company side. And Andrew, specifically, I'm just curious, how do you think the change will impact your business, and what strategies are you following to minimize the effects?
Sure. I think it was a big impact for us. We have somewhere between 20% of our employees that fell in that below the threshold. So we definitely needed to look at each one individually, each job, and do a cost-benefit analysis just to see how we would go about tackling it. So, and I'll go a little bit more into detail about that. What we would do is, or what we did, is we looked at each job individually, and we sat down with the managers, because here at Trunk Club, no one knows if these people were working a lot of overtime or not. So we had to sit down with them and see, like, what is their typical schedule? Did the job require overtime? What did the job entail in terms of tasks and duties and so forth? And then we made an evaluation at that point of what we should do. Certain individuals, it was easier for us to move them above that threshold, and then certain individuals, it just made sense to leave them and kind of change the structure of how they would start to report hours, record overtime, and we can pay them appropriately.
Thanks for that, Andrew. And Brian, sorry to screw up your flow a little bit here, but we'll be asking, as you know, Andrew, questions on the next slide as well.
Understood. And very good practical observations there. I think one that Andrew made that's very important is when you're trying to decide what your ultimate strategy is, you have to start by figuring out what the hours worked are, and that in itself for employees who've been exempt can be a challenge. And then taking a look at the next slide, we have some unique issues that are posed here. The employees, again, who fall in the band between $455 a week and $913 a week are often assistant managers, people with we expect initiative to be self-starting, to not require authorization for all the overtime they work. Some of their duties may be more diffuse. They may be answering the phone more often on the weekend. They may be informally on call. And we have to think about structure for those employees in the future if we reclassify them to non-exempt. And one of the other things that we want to bear in mind is the collateral that employees who are reclassified from exempt to non-exempt may feel actually a diminution in their status in the organization. And a lot of employees are very happy to be salaried, even though they may work long hours. They're proud of their salaried status. That's going to go away, and a transition plan has to include those emotional consequences as well as the practical consequences. And the practical consequences best addressed by training all new non-exempt employees where meal and rest periods are regulated, make sure that people understand how frequently and how long they have to be. You can schedule your meal and rest periods if that increases your compliance with your meal and rest period obligations.
Hey, Brian, this is perfect opportunity to interject, and again, sorry to screw up your flow a little bit here, because on this subject that you just addressed, I'm curious to hear from Andrew's perspective. How do you handle communication with reclassified employees? And do you have any suggestions on strategy on how to handle reclassification in general?
Sure. I would say with any type of change management initiative, we had to go about communicating from several venues or several different ways. So we do have a platform called Lessonly where we put out lessons for employees to take, and they've started to communicate, okay, this is the change, this is how it impacts you, and this is what you'll need to do going forward. So that was one of the ways, as well as having a general Q&A session during lunch, kind of like lunch and learns almost, where they would be able to sit down and kind of discuss this, and then they would ask us questions. Why are we doing this? How it impacts them personally. So we gave them a venue to kind of voice those concerns, and we will be able to provide them with answers to those solutions. So it wasn't easy. However, we definitely were very thoughtful with how we communicated to everyone if we chose to reclassify them. And in the end, the intent was always, we want to make sure that you are paid adequately, fairly, and appropriately to be in compliance with this law or with this new law. And I believe everyone walked away knowing that this was an approach that was more advantageous to them as the employee as opposed to us as the employer.
Thanks for that, Andrew. And Brian, you were about to get into on call, off the clock, and sort of remote workers. This is actually an area where both live and in advance of the webinar, we received a lot of questions. So maybe you can pick up there.
Well, thanks very much for that. And it sounds like Andrew's put a lot of very well-deserved effort into a good communication program. We do have, as we transition the group of employees, those who will not get a wage increase, who will transition to non-exempt status, issues around on-call time, off-the-clock work, and remote work. Each of those is a particular challenge. On-call time can be work time or not, depending upon whether the employee is free to go where he or she wants, the frequency of calls back to the place of employment, and the response time to the place of employment. We talked about off-the-clock work, remote work. A lot of employers will not authorize non-exempt employees to work remotely because they just feel that they lose track of the time. They run into potential off-the-clock issues. One of the challenges, of course, in today's tech world, where a smartphone can take you, to the server, the company's server generally often, is making sure we've made some sound decision making about who can and can't work off the clock. Why don't we press on to the next slide, if we want to save a lot of time for questions and answers. And we want to think about the effect on nonprofits. And here I want to emphasize differences between federal law and state law. Many states regulate overtime. Just about every state regulates the minimum wage at whatever rate it chooses. Federal law doesn't preempt or preclude a state from regulating when overtime occurs and how much a state requires as a minimum wage. We've all seen a recent trend towards local municipalities, often through ballot initiatives, implementing living wages, which are substantially higher than the state and much higher than the federal minimum wage. The federal wage and hour law is theoretically a law of limited applicability. It applies to business enterprises which have a gross dollar volume of revenue of $500,000 a year or more. Well, that $500,000 used to be a meaningful threshold when it was first implemented, about 24 years ago, or first last updated 24 years ago, but now it can touch just about every business. The little twist there for nonprofits is that technically a nonprofit which is truly a nonprofit and doesn't have any subsidiary for-profit activities has no dollar volume of business done because it's not in business, it's a nonprofit. So that looks like a little bit of an outlet for nonprofits, but we need to appreciate that under the federal wage and hour law, there's both the business test for the law applying, and there's what's called the individual coverage test. So federal overtime law can apply to you in two different ways: dollar volume of business over $500,000 a year, or an individual who's engaged in interstate commerce or engaged in the production of goods for commerce. And that is a very, very broad definition. It includes, essentially individuals, a company or a nonprofit that has employees who have worked on goods that have moved in interstate commerce. Well, if you look at the pen you're holding in your hand, it probably moved in interstate commerce at some point, unless you were, the 1 out of 50 states where that pen was made. And if the pen was made in your state, then the handset that you're holding may have been made somewhere else. So there's no general exclusion for nonprofits. Nonprofits are characterized by volunteer work. We want to remember that only nonprofits can have volunteers under the federal wage and hour law. For-profits, individuals who, quote, volunteer, are really just suffered or permitted to work, and that distinction has to be maintained. Employees of nonprofits can also volunteer to service a nonprofit, but they have to volunteer in a role other than that which they occupy. For example, an accounts payable clerk in a hospital could volunteer to sit with patients, but we do need that difference in role to cut off the obligation to pay for the time spent volunteering. Higher education, also the subject of our next slide, has some significant impacts here. The new salary pay threshold will apply to institutions of higher learning. The tuition is going to go up for the kids one more time when you get the checkbook out for the spring tuition payment, for those of you fortunate to have kids in college. One thing that moderates the impact of the new salary pay rule is that teachers don't have a salary pay requirement. Doctors who are practicing law, lawyers who are practicing, doctors who are practicing medicine, although given the number of malpractice claims, maybe all doctors practice law. Doctors who practice medicine and lawyers who practice law are also excluded from the salary pay obligation. There's simply not a salary pay requirement for them. That's also true for outside salespersons who can be overtime exempt even though they're not paid a salary. In fact, they could be paid nothing. If you could get the Fuller Brush man to work for you for free, going door to door, spending all that time outdoors, that person wouldn't require a minimum salary. Coaches may qualify as teachers. There's a special rule for administrative staff in institutions of higher learning. Lots of good detail around research assistants. I think the other real important note about institutions of higher learning is that if it's a state institution, one of the many fine state universities we have across the United States, and it's a public agency of the state, then you can use comp time to pay overtime rather than incur to help offset the cost of overtime. Let's go on and look at another group of employers that sometimes get special treatment. Those are state and local governments. The Fair Labor Standards Act does apply to state and local governments. There are some exceptions for certain core, I'll just call them core functions of the state, where certain elected officials and their assistants may be specifically excluded from the overtime obligation. But as a general rule, the FLSA will apply to state governmental bodies, local governmental bodies. Again, the distinctive advantage of a public agency, which is a state public agency or a public political subdivision of the state, so you can use comp time to offset the cost of overtime. Comp time for public employers can accumulate up to a cap of 240 hours or 480 hours for certain employees. You do have to give the comp time at an hour and a half off with pay for each overtime hour worked, so it's a deferred cost savings, but it's not a immediate, it's not a total cost savings. And one of the largest sources of controversy is the fact on the comp time rules, the Department of Labor has taken a stringent position that an employee should be able to take comp time unless it would unduly disrupt the operations of a public agency, and the DOL sets a very high standard there. There are special rules for firefighters and law enforcement in activity, really based upon number of days in a tour of duty. That's Section 7K of the Fair Labor Standards Act. There is a special process for setting up your work period for such employees. You want to make sure you follow it precisely, otherwise you may lose the cost advantage there. Let's look at the state level a little bit. We have to comply, of course, with federal law, state law, and increasingly with local laws, as well as those federal laws and state laws. One of the distinctive things that we need to bear in mind is that while this increase in the federal minimum salary requirement from $455 a week to $913 a week, or $47,476 a year, may look punishing, the states may well beat that in the near future. For example, California's minimum salary requirement is tied to California's minimum wage. The minimum salary is 2 times the minimum wage times 40 hours in a full-time week. And California's minimum wage will increase from $10.50 in 2017 to $15 an hour in 2022. And that means if we figure out the minimum salary, the California's minimum salary will increase above the federal minimum salary on January 1st of 2019. An overtime exempt white-collar employee in California will have to be paid $50,000 a year in 2019, and that minimum salary in California will increase each year until 2022, when the minimum salary reaches a somewhat astounding $62,568 a year. If you are making a pay change, we want to be mindful of the fact that states may require advance notice of that. The states vary tremendously in that regard. Many states only regulate require notice for decreases in wage rate. You do have the option, for example, of backing down, of taking someone's weekly salary and dividing it by more than 40 hours to come up with an hourly rate to offset some of the cost of overtime. That's okay under the Federal Fair Labor Standards Act. You'd want to keep an eye on state law as well. My experience has been that a lot of employers think, I'll offset the cost of overtime by reducing the hourly rate a little bit, so my time and a half rate is a little less punishing. But often, once you start paying overtime, again, my experience has been managers begin to limit the overtime hours, and that limit on overtime hours often results in the employee earning less several months after the rate change. So you have to be very careful about that strategy for cost containment. Connecticut, Delaware, Idaho, Maryland all require advance notice of reductions in pay. Missouri, 30 days advance notice of reductions in pay. Many other states have notice requirements that we want to bear in mind. The increases, of course, we've talked about here in California. California also has some very distinctive legislation providing overtime now for farm workers on a much more regularized basis, and we also have the California Computer Professional requirement. This was actually, I think, drafted by the realtors in California who wanted to make sure that people in Silicon Valley earned enough money to afford a home. In California somewhere. In California, it will increase to $88,318, remarkably, in 2017. The weekly salary is going to be equally striking. The hourly pay rate will, in California, for an exempt computer, will increase to $42.39 an hour. That's the derivative of the $88,000 salary. So we need to watch state law. One of my colleagues from New York sent out an email yesterday saying the New York Department of Labor has just announced proposed regulations that will result in substantial increases in the minimum salary to be overtime exempt there, just as we've seen a real wave of minimum wage increases on the state level, far outstripping those imposed by Congress under the Fair Labor Standards Act. I think we're going to see more state activity increasing minimum salary amounts in order to be an overtime exempt executive, administrative, or professional employee. And with that, I think we have...
I think we're on the last slide before we get to the Q&A, Brian. So I'll let you go through this one, and then I just a reminder to the attendees, we're already getting a ton of questions flowing in, so would strongly suggest that you submit your question now before we dive into the Q&A, with the knowledge that we're probably not going to get to all of them, but we're definitely going to do our best. Brian, I will let you wrap up with this slide, and then we'll dig in.
Thank you. And that was Sunil picked up on my drum roll of the dramatic pause. You know, do we have relief coming from the courts? And the answer is sort of maybe. There are at least 2 lawsuits. I'm very proud to say my firm is lead counsel in one of those lawsuits, in which primarily states have sued the federal government, alleging that the increases in the salary rate of pay are have 2 fundamental flaws. One is simply the tremendous impact on state governments, disruption of budgets because of the increase necessary, either the increase in overtime or the increased salaries to reclassify individuals. That's based primarily on the 10th Amendment to the United States Constitution, which promises that state governments will be free of certain federal government regulation. The other major challenge is the indexing of future increases to the cost of living. A lot of the focus there is that the exemptions were really, or the argument is that the exemptions were really based on duties, with salary as a secondary indicator of sort of a minimum floor on exempt status, and the emphasis now has changed to the salary driving exempt status rather than duties. What should we do? Should we exit the webinar at this point, be satisfied that nothing's going to happen for several years as the case winds its way through its courts? And I would say not at all. I think you have to continue your preparations for the change in the minimum salary requirement effective December 1st. We certainly hope that we'll get activity from the court that would support some delay here, but trying to enjoin an act of a federal agency is a rather large undertaking, and so continued planning is certainly prudent. We don't want to be out of compliance should the legal action not succeed. There's been action in Congress as well. The House passed a resolution to delay the implementation of the salary increase by 6 months, but President Obama has promised to veto that, undoubtedly would. It doesn't look like there are enough votes to override the veto, so let's not expect an override from Congress either as a potential source of solution or solace, as it may be here, solace for the budgets. And with that, we have arrived at the Q&A. And Sunil, I will turn the program back to you as the moderator. And if you want to fire away with some questions, we'll have some fun.
Yeah. So we're definitely going to go through the Q&A. In advance of that, just wanted to say thank you to to Brian and Andrew. Let's just dive right in. Andrew, we wanted to start with you, and there's some questions around remote and telecommuting employees, and that being a challenge. I know that you face that every day in your role, as you have a lot of remote and telecommuting employees. How do you manage their productivity and overtime at the moment?
Sure, we do look at different metrics for their productivity, because for us, we are a business that has over 90% of our employees are millennials. So working from home or having some aspect of the role where they are remote, that is going to be the case. We are moving more and more towards that. So what we've done is we've looked at other metrics. Because we're Trunk Club and we're into fashion, clothing and so forth, some of the things that they do by working at home is servicing some of our clients and so forth and so forth. So we're looking at sales. We're looking at all of these other things that prove to us that they are working and that they are productive, although they're maybe on the run or in the car or at home, and that has worked out great for us.
Thank you, Andrew, for that. We have some more questions for you, which we'll get to in a moment, but want to go back to Brian for a second here. We have some interesting questions around the duties test. So here's one. We have employees whose job title is manager and are salaried. Are they exempt from overtime pay?
Well, Sunil, a salary is a minimum prerequisite to be exempt as an executive employee. We have to make sure we pay the new minimum salary to that employee. We also have to make sure that we meet the duties test. And under the Fair Labor Standards Act, which is the federal law of general applicability, to meet the duties test, you have to have a primary duty, which is management of the enterprise. That's why we call it the executive exemption and not the supervisory exemption. You have to be a supervisor plus. You have to be the plus being in charge of a recognized subdivision of the business. And you have to engage in managerial duties, which are hiring, firing, distributing work, evaluating work, directing work, planning for work. Those things are what will allow you to be exempt. We also have to be mindful of state law. And for example, here in California, the primary duty test is measured relentlessly, I might say, with a stopwatch, in the sense that primary duty has to be you spend more than 50% of your time in exempt work in the week. And if one week has too much non-exempt work, you'd be eligible for overtime on a week-by-week basis. And under California law, we do have to manage, the subdivision of the business. You must also customarily and regularly direct the work of 2 or more other full-time employees. You have to have the authority to hire, fire, or make effective recommendations regarding same. You must customarily and regularly exercise discretion and independent judgment. So it's comes down to really identifying what are the individual's duties, making sure they have a designated subdivision of business for which they're responsible, and making sure that their exempt duties comprise their primary duty, either under federal law or the more restrictive requirements of state law.
Thank you, Brian. So we're gonna continue with our Q&A. Very interesting question related to independent contractors, and Brian and Andrew, please feel free to chime in both as appropriate. So we have an employer with a few independent contractors that work 40 hours a week that are paid on monthly retainer. Do they need to become hourly? And if so, do we have to pay them overtime?
This is Brian. I would say that if they are true independent contractors, then of course the new minimum salary requirement, which applies to employees, won't apply to them. But I think the challenge really is that a monthly retainer for an independent contractor sounds a little bit like you're sort of salaried, and we want to remember that misclassifying an employee as an independent contractor can lead to a variety of bad consequences. One is claims for overtime, if overtime is worked, and if the person isn't paid on a salary basis and doesn't meet the duties requirements. Another is tax obligations. Another is benefit obligations. Depends upon how the plan is written and whether the addition of the independent contractors would cause the plan to discriminate, could lose its tax qualified basis. And there are a variety, and immigration, another issue. If the person's an independent contractor, you don't need an I-9 form. If they're an employee, we definitely need that. So a simple answer is if you're an independent contractor, new salary requirement has no impact, but beware, there are a lot of cases and claims regarding misclassified independent contractors pending right now.
Thank you, Brian. So we're going to continue with the Q&A momentarily. At this time, the brief plug for Replicon begins. It'll take about 30 seconds, so just bear with us here for a second, and then we'll continue with our Q&A. Who are we and why are we putting on this webinar? Just thought we would share that for a second. Replicon has been in the business of helping companies basically stay compliant over the years, through modern user experience, cloud-based apps. We basically help a ton of companies of all sizes comply with overtime rules. So just wanted to mention that as you're thinking about compliance and time management for all types of workers, worker classifications, and company sizes. We do offer, discounts. So as you're thinking about getting ready for December 1st, please do consider us. We'd love to work with you regardless. We're glad that you are attending this webinar. And so we have, I guess, to wrap up for these last couple of questions. So to our attendees, first of all, just a little housekeeping. Email us your additional questions that you think about that you didn't already submit to webinars@replicon.com, or Brian has graciously volunteered his email on this slide, as you can see. I presume that's because you don't mind people contacting you, Brian.
That's true.
And then, please email us at webinars@replicon.com. We'll send you all of our collateral that we have available. But once again, please go to replicon.com/resource/ebook overtime. We will be able to answer most of your questions through that ebook. We, of course, recommend that you retain your own attorney, and this should not be construed as specific legal advice for your business. The context does change depending on what industry, et cetera, you're working in. So, use this as a set of guidelines. And so, with that little prelude, we have a couple of questions from creative agencies, Brian, which I find interesting. So basically, do different rules apply to creative fields such as marketing, advertising, event production, and graphic design? Follow-on question to that, we had sort of a question that was in the intersection of that, and do unlimited time off policies affect overtime implementation at all? And how should companies think about that? So question 1, creative fields, any different rules? Question 2, unlimited time off, and how does that, if at all, impact overtime?
Well, if you and Andrew and the participants don't mind a little tongue-in-cheek humor, I think the important thing to remember as a creative agency is don't be too creative about overtime, because the same rules apply to advertising agencies, to theatrical agencies, to graphic designers, that apply to other businesses. And we need to be sensitive to that. And one of the greatest challenges is applying the artistic professional exemption, where you have to figure out, where the scope, really, it's the scope of subject matter is broad enough for the individual to qualify as an exempt professional. A graphic designer who, takes the company's logo and moves it around on the annual report from the lower left-hand corner to the upper right-hand corner, while it might be creative and we might have some new color tinting and background, is likely not going to be an overtime exempt employee. So that's really the thrust of issues around creative agencies. I've done You know, California, again, you have to keep state law as well.
A very common use case that we're dealing with at the moment. So if you're looking to get compliant in a short amount of time, email us. Just email the webinars address, and we will reach back out to you ASAP, and we will help you get ready. If nothing else, at least we can send you some additional materials which could be helpful for you during your own implementation process. Download the ebook. The ebook is very good. And we'll be doing more around this. So I hope this was helpful. And even if you email us with feedback, that'd be great. And we'll send these questions along to both Brian and Andrew for reference. And to the extent that they're available, they'll respond to all of them. Thanks to all. We're here to help, and look forward to hosting you again in the very near future. Thank you and goodbye.
Thank you, Sunil.